The Senate Judiciary Committee hearing room fell silent as 90-year-old Senator Chuck Grassley of Iowa leaned forward with a satisfied smile. The ranking Republican member, known for his decades of experience in congressional hearings, believed he had finally cornered Representative Jasmine Crockett with what he thought was an irrefutable legal contradiction. "So, Representative Crockett," Grassley said, his voice carrying the authority of his nearly half-century in Congress, "you've just argued that these documents are protected by executive privilege. Yet 3 minutes ago, you claimed they should be available through FOIA requests. Those positions are fundamentally incompatible, as I'm sure a lawyer like yourself must realize." The room tensed with anticipation. Several Republican senators exchanged knowing glances, while Democratic members shifted uncomfortably. This joint hearing on government transparency had been contentious all morning, but Grassley's challenge seemed designed to undermine Crockett's credibility in a single stroke. The camera zoomed in on Representative Crockett's face as she calmly reviewed her notes. Known for her razor-sharp legal mind and unflappable composure, the Texas Congresswoman and former civil rights attorney took a deliberate sip of water before looking up. What happened next wouldn't just rebut Grassley's challenge. It would transform a routine oversight hearing into one of the most discussed legal exchanges in recent congressional history, leaving the veteran senator visibly stunned and forcing a complete reassessment of the legal framework being debated. Before we reveal Representative Crockett's powerful response that left Grassley speechless and changed the course of this critical hearing, make sure to hit the subscribe button and turn on notifications. This is the kind of substantive political analysis that's becoming increasingly rare, and your support ensures we can continue bringing you these pivotal moments as they happen. To understand why this exchange sent shockwaves through Washington, we need to recognize who these two lawmakers are and the very different approaches they bring to congressional oversight. Senator Chuck Grassley, at 90, was a Washington institution. First elected to the Senate in 1980 after serving in the House since 1975, the Iowa Republican had participated in more high-profile hearings than perhaps any other sitting member of Congress. With his distinctive gravelly voice and farmer's pragmatism, Grassley had built a reputation as a tough questioner who prided himself on his mastery of procedural rules and legal technicalities. Throughout his career, Grassley had positioned himself as a champion of government transparency and accountability. He had co-authored whistleblower protection laws and frequently advocated for stronger Freedom of Information Act (FOIA) provisions. In recent years, however, critics had noted an increasing tendency toward partisan application of these principles, demanding transparency from Democratic administrations while accepting greater secrecy from Republican ones. In committee hearings, Grassley was known for setting verbal traps for witnesses, often using his folksy demeanor to disarm them before springing technical contradictions he believed would undermine their testimony. After decades on the Judiciary Committee, many considered him one of the Senate's most skilled interrogators, particularly on matters of legal procedure and statutory interpretation. Representative Jasmine Crockett, by contrast, represented a new generation of congressional leadership. At 43, the freshman Democratic Congresswoman from Texas had already distinguished herself as a formidable presence in hearings. Before entering politics, Crockett had built a successful career as a civil rights attorney, developing expertise in both constitutional law and the practical application of federal statutes. What set Crockett apart from many of her colleagues was her methodical preparation. Behind the scenes, staff members described her practice of spending hours researching obscure legal precedents and statutory history before hearings. While some representatives relied on staff-prepared questions, Crockett was known to draft her own, often incorporating references to specific court cases and legal doctrines that witnesses wouldn't expect a member of Congress to know. Her background as a trial lawyer gave her another distinct advantage in congressional hearings. Unlike politicians who use their questioning time primarily for speech-making, Crockett approached hearings like courtroom cross-examinations, listening carefully to witness responses and adapting her follow-up questions accordingly. This dynamic approach had already produced several viral moments in her short congressional tenure. The joint Senate-House hearing on Government Transparency and Executive Privilege, had been convened amid ongoing disputes over document production between Congress and the executive branch. The official purpose was to clarify the legal boundaries between legitimate executive privilege and the public's right to government information. But the political subtext was clear. Both parties were positioning themselves for anticipated document battles ahead of the next election. The morning session had featured testimony from legal experts representing various perspectives on executive privilege, FOIA exemptions, and congressional oversight authority. The afternoon session, where the confrontation occurred, included testimony from current and former officials from the Justice Department's Office of Legal Counsel, which plays a central role in defining executive privilege. Grassley's line of questioning had focused on trying to establish contradictions between Democratic positions on executive privilege during different administrations. He had repeatedly referenced documents from both the Obama and Trump eras, suggesting that Democrats had reversed their legal positions based solely on which party controlled the White House. When Crockett's questioning turn came, she had focused initially on the technical distinction between different types of executive privilege claims and their interactions with FOIA exemptions. She had walked the witnesses through a detailed analysis of how deliberative process privilege, a form of executive privilege, differed from presidential communications privilege, and how these distinctions affected FOIA processing. It was during this line of questioning that Grassley believed he had identified a contradiction in Crockett's position. Using his privilege as ranking member to interject, he had interrupted with his challenge about the supposed incompatibility between executive privilege and FOIA accessibility. A gotcha moment he clearly thought would embarrass the younger representative and reassert his own legal expertise. The tension in the room was palpable as everyone waited for Crockett's response. Republican members anticipated a rare stumble from the normally composed Congresswoman, while Democrats wondered if she had indeed made a technical error in her legal reasoning. If you've ever noticed other instances where seasoned politicians have tried to use their experience to trip up newer members of Congress, we'd love to hear your thoughts. Have you seen other exchanges where congressional veterans have underestimated their younger colleagues? Share your observations in the comments below. We value your insights on these important dynamics in our democratic institutions. Thank you for that question, Senator Grassley, Crockett began, her voice measured and confident. I believe there's been a misunderstanding of my position, which actually gives us an excellent opportunity to clarify a nuanced legal distinction that's central to this hearing. She opened a leather-bound legal reference that had been sitting on the table before her. The deliberate way she turned to a pre-marked page suggested she had anticipated this very challenge. Senator, with respect, the apparent contradiction you've identified isn't actually a contradiction at all. It's a reflection of how executive privilege operates within our legal system. If I may explain. Grassley nodded, still looking confident in his challenge. Please do, Representative. As I'm sure you're aware, Senator, executive privilege isn't a single monolithic shield. It's actually a collection of distinct privileges with different scopes and limitations. Crockett held up a document. I have here the Department of Justice's own guidance from 2014, which distinguishes between at least 5 separate forms of executive privilege. She began ticking them off on her fingers. Presidential communications privilege, deliberative process privilege, attorney-client privilege, law enforcement investigative privilege, and state secrets privilege. Each has different requirements and, critically for this discussion, different interactions with FOIA. Grassley shifted slightly in his seat, his expression suggesting he hadn't expected such a specific response. The distinction I was making earlier, which I believe led to your question, concerns the difference between deliberative process privilege and presidential communications privilege, Crockett continued. Deliberative process privilege is qualified, meaning it can be overcome by a sufficient showing of need, and importantly, it's explicitly recognized as an exemption under FOIA through Exemption 5. She turned to the witness, a current Justice Department official. Ms. Harrington, Would you confirm that deliberative process materials are handled under FOIA Exemption 5? That's correct, Congresswoman, the witness replied. Thank you. Crockett turned back to Grassley. Now, presidential communications privilege, which protects direct communications involving the president, is rooted more directly in constitutional separation of powers and is consequently stronger. But here's the crucial point. Even this stronger form of privilege is not absolute when it comes to congressional oversight, or, in some cases, FOIA. She held up another document. I have here the D.C. Circuit's ruling in Judicial Watch versus Department of Justice, which held that even materials potentially covered by presidential communications privilege must still be reviewed for potential release under FOIA. Crockett paused, ensuring her explanation was clear. So when I stated that certain documents should be available through FOIA requests despite potential executive privilege claims, I was precisely referencing this established legal framework, not contradicting myself as you suggested. The room had grown notably quiet as committee members from both parties realized they were witnessing not a political talking point exchange, but a sophisticated legal discourse. Several staffers could be seen taking detailed notes. Grassley, however, wasn't ready to concede. Representative Crockett, that's a convenient explanation, but it doesn't address the specific documents we were discussing, which clearly fall under presidential communications privilege. Crockett nodded as if appreciating the follow-up. Actually, Senator, that's exactly the point I was making before your interjection. The documents in question, internal Department of Justice memoranda discussing the implementation of the policy, do not directly involve the President's communications and would therefore fall under deliberative process privilege, not presidential communications privilege. She referenced her earlier questioning of the witness. As Ms. Harrington confirmed in response to my questions, these documents record deliberations between agency officials, not direct presidential communications. Under the controlling case law, specifically in resealed case, which I believe you're familiar with from your Judiciary Committee work, such materials fall squarely under deliberative process privilege. Grassley frowned, clearly not expecting this level of legal detail. That case involved very different circumstances. With respect, Senator, Crockett responded without missing a beat, the principles established in that case have been consistently applied by federal courts. In fact, the case explicitly distinguishes between presidential communications privilege and deliberative process privilege in ways directly relevant to our discussion. She picked up yet another document. I have here the specific language from the D.C. Circuit. The deliberative process privilege is a general privilege that applies to all executive branch officials. The presidential communications privilege, on the other hand, is specifically rooted in constitutional separation of powers principles and the president's unique constitutional role. Crockett continued, her tone remaining professional and devoid of condescension, despite her clear command of the material. So when I stated that these specific documents should be subject to FOIA while acknowledging they might involve a form of executive privilege, I was making precisely the distinction the D.C. Circuit outlined, that deliberative process materials, while potentially privileged, are still processed under FOIA with Exemption 5 analysis. The dynamic in the room had shifted noticeably. Several committee members who had been checking phones or whispering to staffers were now fully engaged, watching an unexpectedly substantive legal debate unfold. Grassley, recognizing that his gotcha moment had backfired, attempted to pivot. The broader point remains that the current administration is inconsistently applying these principles compared to their stated positions during the previous administration. Crockett nodded thoughtfully. That's a separate and valid concern for this committee to explore, Senator. But it's distinct from the legal framework question you raised about my supposedly contradictory positions on privilege and FOIA. She paused before adding, and if we're concerned about consistency across administrations, I'd be happy to discuss the significant shifts in executive privilege assertions between 2016 and 2020 as documented by the Justice Department's own Office of Legal Counsel. This reference to potentially problematic precedents from the previous administration caused Grassley to visibly recalibrate. He glanced down at his notes, apparently reconsidering his approach. "I think what's important here," Crockett continued, filling the momentary silence, "is that we move beyond partisan applications of these principles. Executive privilege, in all its forms, exists to protect the functioning of the executive branch, not to shield information from legitimate oversight or public accountability." She turned to address the full committee. "The legal framework I've outlined, distinguishing between different forms of privilege and their interactions with FOO and congressional oversight, should apply regardless of which party controls the White House. That's why I've been asking the witnesses about codifying clearer standards that would create more consistency." The committee chairman, recognizing the substantive turn the hearing had taken, intervened. "Representative Crockett has made some important legal distinctions. Senator Grassley, did you have additional questions on this point?" Grassley, now clearly on the defensive, shuffled his papers. "I'll reserve my remaining questions for the next round." The chairman nodded. "Representative Crockett, you may continue your questioning." Crockett turned back to the Justice Department witness. "Ms. Harrington, I'd like to explore further how your office distinguishes between deliberative process materials and presidential communications when processing congressional oversight requests. Specifically, what documentation do you require to substantiate a claim that particular documents involve direct presidential communications?" As Crockett continued her methodical questioning, the atmosphere in the hearing room had transformed. What had begun as an attempt to embarrass a junior member with a perceived contradiction had evolved into one of the most substantive discussions of executive privilege law seen in the committee in recent memory. Congressional staffers could be seen frantically Googling the cases Crockett had cited, while several committee members were visibly reassessing the freshman representative. Even some Republican members appeared impressed by the precision of her legal analysis, regardless of whether they agreed with her policy positions. The exchange continued for several more minutes, with Crockett guiding the witnesses through a detailed discussion of how executive privilege determinations are made within the Justice Department. Throughout, she demonstrated not just theoretical knowledge of the relevant law, but practical understanding of how these principles are applied in real government operations. As her questioning time neared its end, Crockett returned to the broader implications. "What concerns me, Ms. Harrington, is that without clearer statutory guidelines, these determinations remain too susceptible to political influence. Would you agree that more explicit standards for distinguishing between different forms of executive privilege would benefit both the executive branch and those seeking information through FOIA or congressional oversight?" The witness, a career Justice Department official, responded carefully. "Speaking personally rather than for the department, greater clarity would certainly help our attorneys make more consistent determinations across administrations." Crockett nodded. "Thank you. I believe that's a goal members of both parties should support." As her time expired, Crockett had not only deflected Grassley's challenge, but transformed it into a masterclass on a complex area of law. The contrast between Grassley's attempted political gotcha and Crockett's substantive legal analysis couldn't have been more stark. The cameras captured Grassley's expression, a mixture of surprise and reassessment that would soon become one of the most widely shared images from the hearing. As the hearing continued, the impact of the exchange between Grassley and Crockett reverberated through the chamber. Several subsequent questioners from both parties referenced Crockett's legal framework, effectively adopting her distinctions between different types of privilege. When Grassley's turn for questioning came again, he noticeably avoided returning to his earlier challenge. Instead, he focused on technical questions about FOIA processing timelines, tacitly acknowledging that his attempt to corner Crockett had backfired. The most remarkable moment, however, came near the end of the hearing, when Senator Thomas Mitchell, a moderate Republican from Maine, addressed Crockett directly. Representative Crockett, Mitchell began, I want to return to the legal framework you outlined earlier regarding the different types of executive privilege. I found your analysis quite helpful, particularly the distinction between deliberative process and presidential communications privilege. Would you elaborate on how you believe we should codify these distinctions to ensure more consistent application? This acknowledgment from a Republican senator, effectively endorsing Crockett's legal analysis over Grassley's challenge, represented a stunning validation of her expertise. The cameras caught Grassley's reaction as he listened to his Republican colleague implicitly siding with Crockett's position. Thank you, Senator Mitchell, Crockett responded. I believe the key is establishing clear statutory definitions that reflect the case law distinctions I referenced earlier. Currently, executive privilege exists primarily through court decisions and executive branch legal opinions, which allows for inconsistent application. She continued, outlining a thoughtful approach to potential legislation that would clarify the boundaries between different privileges while respecting legitimate executive branch needs. Her proposal included specific standards for distinguishing between deliberative materials and presidential communications, as well as clearer procedures for how Congress could overcome privilege assertions in oversight investigations. What made her response particularly effective was how it transcended partisan framing. Rather than positioning the issue as Democrats versus Republicans, she emphasized the institutional interest of Congress in having consistent standards regardless of which party controlled the White House. The reality, Crockett explained, is that administrations of both parties have expanded executive privilege claims over time, often in ways that undermine both congressional oversight and public transparency. By codifying clearer standards, we would strengthen our constitutional system regardless of who occupies the White House. Several committee members nodded in agreement, recognizing the principled nature of her position. The witnesses, too, seemed to appreciate the substantive turn the hearing had taken, engaging with the technical details of her proposal in a way that rarely happens in politically charged hearings. As the hearing neared its conclusion, the chairman addressed the entire panel. I want to thank all the members for their questions today, and particularly note the substantive legal discussion we've had. It's refreshing to move beyond talking points to engage with the complex legal principles at stake. Without naming names, this was an implicit acknowledgment of how Crockett had elevated the hearing from political theater to substantive policy discussion. The contrast with Grassley's attempted gotcha moment was obvious to everyone in the room. After the hearing concluded, reporters swarmed Crockett in the hallway, many asking specifically about her exchange with Grassley. Senator Grassley is a respected member with decades of experience, Crockett said diplomatically. What today's discussion highlighted isn't about any individual, but about the importance of precision when discussing complex legal doctrines like executive privilege. These aren't just academic distinctions. They have real implications for government transparency and accountability. Her gracious response, refusing to frame the exchange as a personal victory, only enhanced the impression she had made during the hearing. Rather than taking a victory lap, she continued to emphasize the substantive issues at stake. Meanwhile, Grassley moved quickly through the hallway, declining to take questions from reporters about the exchange. His hurried exit contrasted sharply with his usually accessible approach to the press, suggesting he was uncomfortably aware of how the confrontation had played out. Back in the committee room, legal experts who had attended the hearing were already discussing the significance of what they had witnessed. Professor Helen Richardson, a constitutional law scholar who had been observing from the gallery, remarked to a colleague, "That was the most sophisticated discussion of executive privilege I've heard in a congressional hearing in years." Representative Crockett didn't just know the case names. She understood the nuanced legal principles and their practical applications. This assessment was quickly shared by legal commentators as clips of the exchange spread across social media and news outlets. Rather than focusing on the political dynamics of a freshman Democrat challenging a senior Republican, many analysts highlighted the substantive legal content of Crockett's response. On legal blogs and Twitter, attorneys and law professors dissected her citations and analysis, generally finding them accurate and well-reasoned. The consensus emerging among legal experts was that Crockett's framework for understanding different types of executive privilege reflected the current state of the law more accurately than Grassley's more simplified characterization. By evening, the exchange had made its way to primetime news coverage, but not in the way most congressional spats do. Instead of the usual partisan framing, anchors emphasized the substantive nature of the disagreement and Crockett's command of complex legal principles. What made today's exchange between Representative Crockett and Senator Grassley so remarkable, said one legal analyst on CNN, wasn't just that a junior member held her ground against a senior senator. It's that she did so by elevating the discussion to a sophisticated legal analysis that even experts in the field would recognize as accurate and nuanced. On Fox News, even conservative commentators acknowledged the substance of Crockett's response. While I may disagree with Representative Crockett's policy positions, said former federal judge Andrew Peterson, her legal analysis today was sound. The distinctions she drew between different types of executive privilege are well established in case law. Perhaps the most significant reaction came from inside Congress itself. By the following morning, multiple committee chairs had reached out to Crockett's office about her potential involvement in drafting legislation to codify clearer executive privilege standards, including 2 Republican committee chairs who recognized the cross-partisan appeal of more consistent rules. For Senator Grassley, the exchange marked a rare misstep in his nearly half-century congressional career. Known for his careful preparation, he had clearly underestimated Crockett's legal expertise and her readiness to engage on highly technical aspects of executive privilege law. What made the moment particularly significant wasn't just that Grassley had been outmaneuvered in a verbal exchange. Such things happen regularly in Congress. It was that his attempt to score a political point had been transformed by Crockett into a substantive policy discussion that transcended partisan divides and focused on institutional principles that members of both parties could support. In doing so, Crockett had demonstrated a different kind of political effectiveness, one based not on destroying opponents or creating viral moments of conflict, but on bringing substantive expertise to complex policy questions in ways that could potentially lead to meaningful legislative outcomes. The days following the hearing saw an unusual development in Washington, a congressional exchange that continued to be discussed for its substance rather than merely its political theater. Law school professors showed clips of Crockett's explanation of executive privilege in their constitutional law classes. Congressional staffers circulated transcripts as an example of effective questioning technique. For Grassley, the exchange prompted some reflection. Known throughout his career for substantive policy work before the era of viral clips and social media moments, the veteran senator seemed to recognize that he had departed from his own strengths by attempting a political gotcha rather than engaging with the substantive issues at hand. 3 days after the hearing, Grassley did something rare in modern politics. He publicly acknowledged the merit in his colleague's position. During a Judiciary Committee markup session on an unrelated bill, Grassley made a brief but significant statement. I want to note for the record that Representative Crockett raised some important legal distinctions in our joint hearing earlier this week, he said. While we may disagree on policy applications, her framework for understanding different types of executive privilege has merit and should inform our oversight work regardless of which party controls the executive branch. This acknowledgement, from one of the Senate's most senior members about a freshman representative from the opposite party, sent a clear message about the impact of Crockett's performance. In Washington's partisan environment, such cross-party professional respect is increasingly rare. For Crockett, the aftermath brought new opportunities and responsibilities. Her office was flooded with requests for meetings from advocacy groups focused on government transparency and accountability. More significantly, multiple committee chairs reached out about her potential involvement in drafting legislation to clarify executive privilege standards. Rather than using her newfound prominence to seek media attention, Crockett focused on the substantive opportunity. Within weeks, she was working with a bipartisan group of representatives and senators on draft legislation to codify clearer standards for executive privilege claims and their interaction with congressional oversight and FOIA. The Executive Privilege and Transparency Act, as it became known, incorporated many of the distinctions Crockett had outlined in the hearing. It created statutory definitions for different forms of executive privilege, established clearer procedures for how Congress could overcome privilege assertions, and codified standards for when executive privilege could and could not be used to withhold documents from FOIA requests. Most significantly, the bill attracted genuine bipartisan support, an increasingly rare achievement in contemporary Congress. Several senior Republicans joined as co-sponsors, recognizing that, regardless of which party controlled the White House, Congress as an institution benefited from clearer rules governing executive privilege claims. Legal experts broadly praised the proposed legislation. In congressional testimony about the bill, former Justice Department officials from both Democratic and Republican administrations endorsed its approach as striking an appropriate balance between legitimate executive branch confidentiality needs and the public's right to government information. What makes this legislation particularly valuable, testified former Attorney General Michael Williams, is that it doesn't simply favor transparency over confidentiality or vice versa. Instead, it creates clearer rules of the road that would benefit both the executive branch and those seeking information, whether through Congress or FOIA. 6 months after the initial hearing confrontation, the bill passed the House with substantial bipartisan support. While its Senate prospects remained uncertain due to the higher threshold for overcoming filibusters, the fact that meaningful legislation had emerged from what began as an attempted political gotcha moment represented a remarkable outcome. For political observers, the entire episode offered a counter-narrative to prevailing assumptions about what makes for effective congressional performance in the social media age. Rather than creating viral moments through personal attacks or inflammatory rhetoric, Crockett had demonstrated how substantive expertise and principled focus on institutional rather than partisan interests could be not only substantively valuable, but politically effective. What Representative Crockett showed, wrote political analyst Jennifer Martinez in The Atlantic, is that there remains space in our political system for the kind of substantive expertise and institutional focus that used to define congressional effectiveness before the era of viral clips and constant fundraising appeals. Her command of executive privilege law wasn't just impressive in an academic sense. It proved politically powerful precisely because it transcended the usual partisan framing. The contrast with more performative approaches to congressional hearings was stark. While some members used hearings primarily as opportunities to create social media content for their base, Crockett had shown how substantive engagement could actually accomplish more meaningful political results, building cross-partisan coalitions around institutional principles and advancing legislation that addressed real governance challenges. For Grassley, too, the episode had significance as he approached the final years of his long congressional career. Having served in an era when substantive policy knowledge and legislative craftsmanship were the primary measures of senatorial effectiveness, he seemed to recognize in Crockett an approach to governance that resonated with his own earlier career. Before congressional hearings became primarily venues for political performance. In a profile published nearly a year after the hearing, Grassley reflected on the exchange. Representative Crockett reminded me of something important, he told the reporter. When we get beyond trying to score points and focus on the substantive issues, we can sometimes find more common ground than we expect. The executive privilege legislation that emerged from that hearing is a good example of how Congress is supposed to work. For congressional staff and aspiring politicians, the Grassley-Crockett exchange became a case study in different approaches to committee hearings. Many noted how Crockett's preparation, evident in her command of specific cases and legal doctrines, had allowed her to transform what was intended as a political trap into a substantive policy discussion. The key lesson, said one veteran committee staffer in a training session for new congressional staff, is that Representative Crockett wasn't just prepared with talking points, she had genuine expertise on the subject matter. That allowed her to respond substantively rather than defensively, which completely changed the dynamic of the exchange. Law schools, too, found educational value in the exchange. Professor James Sutherland of Harvard Law School incorporated video of Crockett's executive privilege explanation into his course on separation of powers. What makes this congressional exchange unusually valuable as a teaching tool, he told his students, is that it provides an accurate and nuanced explanation of a complex legal doctrine in an accessible format. Representative Crockett manages to be legally precise while remaining clear enough for non-lawyers to follow. Perhaps the most significant legacy of the exchange, however, was its impact on public understanding of executive privilege, a legal doctrine that affects government transparency but is often misunderstood. By clearly explaining the distinctions between different types of privilege and their varying levels of protection, Crockett had helped educate not just her congressional colleagues, but the broader public about this important aspect of constitutional law. As one government transparency advocate noted, before that hearing, most Americans, if they thought about executive privilege at all, probably imagined it as a single, all-purpose shield that presidents could invoke to hide information. Representative Crockett's explanation helped people understand the important legal distinctions that actually define when information can and cannot be withheld from Congress or the public. 2 years after the hearing, as the Executive Privilege and Transparency Act finally passed the Senate and was signed into law, many traced its origins directly to that unexpected exchange between a freshman representative and one of the Senate's most senior members. What had begun as an attempted political embarrassment had ultimately produced substantive legislation, addressing a genuine governance challenge. In the increasingly rare category of Washington's success stories, this one offered a particularly compelling lesson: that in an era often defined by performative politics and partisan warfare, substantive expertise and focus on institutional rather than merely partisan interests could still produce meaningful results. For Representative Crockett, now recognized as one of Congress's leading experts on government transparency and accountability, the exchange with Grassley represented not just a personal vindication, but a validation of a different approach to political effectiveness, one rooted in substantive knowledge, principled focus on institutional values, and willingness to work across partisan divides. And for observers of American democracy, increasingly concerned about Congress's capacity to function amid intense polarization, the entire episode offered a modest but meaningful reminder that substantive expertise, thorough preparation, and focus on institutional rather than merely partisan principles could still sometimes overcome the forces of division and dysfunction that so often define contemporary politics. If you found this analysis of congressional dynamics valuable, please hit subscribe and turn on notifications to support our ongoing examination of pivotal political moments. Share this video with friends and colleagues who care about effective governance and substantive policy discussion. The conversation about how Congress can function effectively in a polarized era is too important to leave to the loudest voices. It requires thoughtful engagement from citizens who value substance over spectacle. What other examples of substantive expertise prevailing over political gamesmanship would you like us to analyze in future videos? Let us know in the comments below.